Hello, everyone. Hopefully you can hear me. Welcome to today's webinar, The Ins and Outs of Guardianship and Conservatorship. My name is Beth Cohen-King. I'm the Marketing Director at Margolis Bloom D'Agostino, and we have Ilana Abramson here today to go into the nitty-gritty of these, what can be very complex topics. So excited to have her here today. I'm sure there will be questions. If you look to the panel on your right, there's a little bar that says questions. Please put your questions in there. We will do our best to answer them after the presentation. Also, just please remember to try to ask as general questions as you can. We can't really answer, very detailed, specific questions. And whatever we can answer due to time, or if we don't know the answer right on the spot, we will follow up afterwards. If you do need to jump off, don't worry. We are recording this. This will be on our website usually within a week. I highly recommend that you check out our resources section on our website. It's Margolis Bloom D'Agostino under resources in the navigation bar. There is a ton of content there. Really can answer a lot of your questions. So we've got videos, different papers that have been written by the different attorneys. Our blogs are extensive, thousands of blog posts. So hopefully you can find some good information there, as well as subscribing to our e-letter. If you haven't already, it will give you all the information, plus it will also have the recording of this webinar. So with that, I am gonna let Ilana take it away, and thank you again for attending.
Great. Thank you, Beth. As Beth said, my name's Ilana Abramson. I'm an attorney at Margolis Bloom D'Agostino, and today I'll be talking about guardianship and conservatorship. As an overview, I'll discuss the differences between the two, when it might be appropriate to seek court involvement to have a guardian or conservator appointed, and then what the process of that is really like. So to begin, I will just start by defining what guardianship and conservatorship is. So the two of them involve the probate court, and the probate court would be involved, and they would give one or more persons the power to make personal or financial decisions for someone else. A guardian is appointed to make personal and medical decisions, whereas a conservator is appointed to make financial decisions. But to back up, how do we even know if filing for guardianship or conservatorship is needed or the right next step? Sometimes you don't have to have the court involvement to seek a guardian or conservator. One of the first things to consider is whether there's a healthcare proxy or a power of attorney. These are two documents that are often drafted as part of an overall estate plan, and it can allow someone who has capacity or has the ability to make this decision about who could be a healthcare agent or power of attorney when the time comes when they're incapacitated and maybe can't make the decision about who that individual might be at that time. And so just to kind of explain even further, a healthcare proxy would name a trusted person to make healthcare decisions in case the principal is unable to make or communicate medical decisions. So again, this is often drafted as part of an estate plan. Sometimes when you go to a doctor's office, you might also sign a healthcare proxy naming someone who can step in and make medical decisions in the event that you're incapacitated. So it can be very helpful to have a healthcare proxy on this. Also, as part of a healthcare proxy, you can include a medical directive, which might have more details about how you might want to be cared for at the end of your life. And so it could be a good way to include those details and that information in a healthcare proxy. Also with the healthcare proxy, it's usually invoked by a doctor at a time where the person's incapacitated. And so when they're incapacitated, at that point, the healthcare agent would step in and make the medical decisions. Another document that is really important is a power of attorney. Again, this is another document that's often drafted as part of an overall estate plan, and it would appoint someone to act in the event of incapacity and can make the financial decisions. Essentially, a power of attorney would step into the shoes of the individual and be able to access bank accounts and other finances. They could also speak to an employer if needed. And so it can be really helpful to have a power of attorney and a named agent. There can also be different kinds of powers of attorney. There could be a durable power of attorney where you might sign a document tomorrow naming someone as your power of attorney, and it would be in effect now, and they could go in, it would be in effect as soon as it's signed, and they could go in and have access to the bank accounts as well. There's also something called a springing power of attorney where you could sign it now, but it might not necessarily come into effect until the individual is incapacitated and a doctor signs off with that. Either way, the power of attorney, has the fiduciary duty to act in the shoes of the principal. And so both of these documents, the power of attorney and healthcare proxy, can be really helpful to have because it can name these individuals to make these medical and financial decisions in the event of incapacity. However, sometimes they don't exist. Sometimes an individual doesn't have one, or they're not sufficient. So if an individual doesn't have a healthcare proxy or power of attorney, and it gets to the point where they're incapacitated and someone needs to step in to make medical or financial decisions, then guardianship or conservatorship is likely the next step. There can also be instances where someone might have these documents, but they're insufficient. So what can that mean? An example with power of attorney is maybe someone has a power of attorney, maybe they name their child as power of attorney, but they're advancing in age, and at some point maybe they become incapacitated and are still trying to access their bank accounts and spending money kind of frivolously or unnecessarily, or they're being exploited, or there's a lot of concerns about the way that they're accessing their account. If a power of attorney is in place, the principal can still access their accounts. So it can both be the principal and the power of attorney. Both of them can access the accounts, but there might be a case where the principal is not in a condition to be able to really have access anymore. And so seeking a conservatorship is necessary so that only the conservator could then have access to those accounts. So that can be an example where the documents are insufficient. Also could be with a power of attorney. Some powers of attorney have a lot of broad powers and authorities and give the named power of attorney the ability to do a lot, like sell real estate or things like that. However, if the document does not necessarily outline a specific power or authority that the power of attorney is seeking to do, then conservatorship might be needed. So that can happen as well. Or if there are, possibilities or thoughts that when they signed the documents, they didn't have capacity. Sometimes a power of attorney might be signed, and then someone tries to go to sell real estate under their name, and then one of the attorneys involved might say, "Oh, I'm not sure if they had capacity. You need conservatorship." So those are some instances where it could be insufficient. So then the next step would be to consider filing for guardianship or conservatorship. When filing for guardianship and conservatorship, as I mentioned, one of the key pieces is at that time they don't have capacity. And so these are the legal standards for capacity. So there needs to be a clinically diagnosed condition, an inability to receive and evaluate information or make or communicate decisions. And with guardianship, they have to lack the ability to meet essential requirements for physical health, safety, or self-care. With conservatorship, they have to be unable to manage property or business affairs effectively, and or has property that will be wasted or dissipated unless management is provided. And so those are the standards for capacity. And with guardianship, as I talked about, is a last resort when an individual becomes incapable of caring for themselves or making proper decisions about their health, living arrangements, and care. And again, it's when the court is involved and the court appoints someone to make healthcare decisions for someone else. And it can also take away some legal rights of that person. There can also be general or limited guardianship, and I'll talk about some of the limited limitations that could be placed on guardianship in a moment. So maybe you're in the situation where, okay, there's no documents or they're insufficient. Someone has the need for a guardian to step in to make medical decisions. There's a belief that they're incapacitated. How do you determine who might be the appropriate guardian? Sometimes if there is a healthcare proxy or power of attorney, it might actually nominate someone who could serve as a guardian or conservator if the time comes. Sometimes there is other information. You might want to think about whether there's a family member, if that could be the appropriate person. Maybe there's two people who could serve as guardian. And so it's important to think about that, or maybe you need a professional involved to be the guardian instead. Also, when considering who it could be, can think about what their role will be. What are they actually going to be doing? They'll be making medical decisions. They'll be making housing decisions, day-to-day decisions. They can make education decisions. And so it's important to kind of consider everything that might be involved when determining who could be the most appropriate guardian to serve. And as I mentioned, there can be the general guardianship where you can have the guardian would be able to make broad medical decisions, or you could also choose for it to be a limited guardianship. And so if that is the request, then part of the court's order includes a limitation sheet where you can check off certain boxes in order for the respondent or the incapacitated person to retain some rights and responsibilities. So these are some of what are on the document that the court provides. So for example, for care to self, you could check off a box that they retain the right to be responsible for bathing, dressing, and toileting and dental care. And they could choose and determine their daily meals. For medical decisions, sometimes, you know, as listed here, they could retain the right to make and communicate decisions for their routine healthcare decisions. They could choose a health or long-term care facility. Maybe they could choose and direct their own home healthcare providers, or they can manage medication. Some of the other limitations that you could choose is that they could, again, I don't necessarily need to read all of these, but that they could retain the right to vote is one of them that you can check off, that they could participate in their own religious activities. They could determine who to have friendships with. And they can, you know, drive without a valid driver's license. So it's possible to check some of these off in order for the individual to retain some of their own rights and responsibilities. And this is case by case. Every situation is different. Sometimes with guardianship, sometimes when parents maybe are seeking guardianship over their young adults, sometimes when someone turns 18 and they have intellectual disabilities or other sorts of diagnoses that lead to their incapacity or inability to make healthcare decisions on their own, and the parents might seek guardianship over them. But because they're so young, they still want to have their child retain some of these rights. So we often see that. That could be different than a situation where someone might be seeking guardianship over their elderly parent who has advanced dementia and Alzheimer's and is unfortunately not in a position to make any of these decisions on their own. And so then general guardianship might be appropriate. Every situation is different. So that is all to consider what is needed for a guardian, who would be appropriate. and things like that. And then you get to the point where, okay, I need to file with the court to have court involvement to have a guardian appointed. And so these are the documents that you can find all online in the court's website that need to be filed with the court. So there's a petition that needs to be filled out with various information about the incapacitated person and the person seeking to be appointed as guardian. In addition, also need to file a medical certificate or a clinical team report. These are the documents that outline why the person is incapacitated. It includes the diagnoses, and it includes kind of how that diagnosis impacts their ability to make various decisions. Medical certificate is tends to be more common as the document that a doctor would fill out. See that for lots of different diagnoses, again, for dementia or Alzheimer's or something like that. The clinical team report would be filled out in times of when there's an intellectual disability. And so that could be, again, sometimes you see that for a younger individual where there might be an intellectual disability. And so then you'd fill out a clinical team report, which can be a little bit more cumbersome only because that needs to be signed by 3 different providers. It needs to be signed by a physician, psychologist, and a social worker, which is different than a medical certificate that only needs to be filled out and signed by a physician. And again, those documents are available online. And then the other documents involved with filing for guardianship are a bond and military affidavit. A bond outlines the assets that the incapacitated person has, and also the proposed guardian has to sign it and just agrees to be subject to the jurisdiction of that court. Military affidavit has to be filled out, and then depending on the circumstances, if the incapacitated person is treated with antipsychotic medications, there are additional pleadings that have to be filed. Specifically, it's called the need for Rogers authority. An attorney will be appointed for the incapacitated person. You'll have to submit findings of facts and a treatment plan and a clinician's affidavit in addition to the medical certificate or clinical team report. So additional documents need to be filed in order to alert the court to the fact that these antipsychotic medications are being used. And basically the court will inquire as to whether the incapacitated person, you know, if they could, would they agree to take those medications? So, so that can be another element to this if it's needed. And also, if Rogers authority is required, then every single year there will be what they call a Rogers review, where you have to submit an updated clinician's affidavit and treatment plan outlining the specific medication that the individual is taking. So what are the responsibilities of a guardian? As we've talked about, they will be able to make the medical treatment decisions, they can make housing decisions, and day-to-day decisions. That's kind of what, again, day-to-day as a guardian would be. But again, because guardianship has court involvement, the court does require there to be certain filings. So after the initial appointment, a 60-day report has to be filed, which is a guardian care plan that just sort of gives a little bit information about how the incapacitated person is doing and what the guardian has been doing in their role so far. Then after that, every year, another annual care plan has to be filed. And as I mentioned, if Rogers authority is needed, then in addition, all of the Rogers pleadings would have to be filed every single year. And the court does schedule a review hearing that should be done administratively. So as long as everything is filed, it should be all set, but always worth checking in on that. Okay, so the guardians do have a lot of authority and the ability to make these medical decisions, but it's not, it doesn't give them the ability to do absolutely everything. So a guardian is not able to remove a healthcare proxy without specific court authority, can't spend or give out the person's assets, and isn't personally responsible for their expenses. So again, a guardian doesn't really have access to the finances. That's for the role of a conservator. But again, for the need to remove a healthcare proxy, then you would need to request additional authority. And I'll talk about the process for that in a moment, about requesting expanded authority in order to make certain decisions, because that's something that you could request for both guardianship and conservatorship. So I'll talk about that in a moment. All right, next is conservatorship. So a conservator may be appointed for a person to be protected if the person is unable to manage property and business affairs effectively because of a clinically diagnosed impairment in the ability to receive and evaluate information or make or communicate decisions, even with the use of appropriate technological assistance. And the person has property that will be wasted or dissipated unless management is provided or money is needed for the support, care, and welfare of the person or those entitled to the person's support, and that protection is necessary or desirable to obtain or provide money. So that's a long way of saying that conservatorship can be needed or is the right next step if the person's incapacitated and isn't able to manage their own finances. So some of the responsibilities of a conservator is that they serve as a fiduciary. So they're responsible for managing the protected person or the incapacitated person's property, but again, only as the court authorizes in the decree and order. They can also encourage the protected person to participate in decisions, act on their own behalf, and regain the ability to manage their estate and business matters if possible. The conservator also should update the court with any address changes, and also if the protected person dies, they'll have to notify the court. Similar to the documents needed for guardianship, these are the documents needed for conservatorship. Again, there's a petition, medical certificate, or clinical team report, a bond, and a military affidavit. If there's no kind of Rogers involved with conservatorship though. So after appointment, like we talked about with guardianship, where you have the annual care plan, with conservatorship, there's also annual filing requirements with the court. So there's the initial inventory, which has to be filed within 90 days of the appointment. And the inventory is provides a snapshot of all of the assets of the protected person or incapacitated person as of the date that the conservator is appointed. This is so the court has an idea of all of the assets that the protected person has that then the conservator is about to manage. So the inventory has to be filed within 90 days to demonstrate that. And then after that, every single year, annual accounts have to be filed. And the accounts really show all of the assets of the protected person and every transaction, just to show that the conservator is complying with their fiduciary duties. And so that would be filed each year. If the protected person dies or upon their passing, then what's called a petition for order of complete settlement would need to be filed. That kind of brings everything together and wraps up the entire conservatorship. Also, a conservator's financial plan might also need to be filed. There's a specific box on the court's order that might require that. Not every court requires it and not in every case, but sometimes they would. And so it's always important to read the court's order really closely to see what exactly they require and the timing of everything. Also important to note with these filing requirements along with the guardian care plan is that the court actually very recently issued a standing order reiterating the importance of filing these documents, and that they're going to be going through it, and they might issue a notice of non-compliance if these haven't been filed. And so they're kind of stepping it up to really make sure that everyone is compliant with these requirements. So as I had mentioned, you have a lot of powers as a guardian or conservator, but it's not unlimited. And so there are instances where you might have to go back to court to seek additional court authority. So for guardianship, Rogers authority, if maybe you have you get guardianship and then down the line there's a need for antipsychotic medication, then you would have to go back to request expanded authority for Rogers authority. If you're seeking to admit the protected or person or incapacitated person to a skilled nursing facility, likely will need to get expanded authority to do that. Mass health, revoking healthcare proxy. I've also seen it where might have to go back if there is no DNR in place prior to the person becoming incapacitated, then you might have to seek court authority to get expanded powers of the guardian being able to execute advanced medical directives such as a DNR or something like that. I've seen that in a couple of cases. And so, so again, those are times where you do have to go back to court to get additional authority to exercise those powers. With conservatorship, similarly, again, a conservator has a lot of authority to be able to manage the finances and things like that, but there are times where you need expanded authority as well. So for real estate transactions, if you're trying to sell a property, then you'll need to get proper permission and additional authority authorized by the court. If the conservator is trying to execute estate planning documents on behalf of the protected person, then they'll have to go back to court and seek authority for that, and same with gifting. So, so things like that, you just have to be aware of and thinking about whether it's authorized under the general conservatorship or whether it's important or really necessary to go back to court to request the additional expanded authority to be able to do those sorts of things. Oftentimes, in those instances, the court might also appoint an attorney to represent the protected person or their interests. And so that might also be part of that process. All right. Okay, so I know I've covered a lot so far, and just kind of to kind of recap the entire process. So even with that's not even listed here, you know, as we talked about, it's to think about whether guardianship or conservatorship is needed, whether court involvement is needed, are there documents in place, are they sufficient or not? And if not, then the next step would be to pursue guardianship or conservatorship. And as part of that, you want to consider who could be appropriate to serve. And then you'll want to get the documentation that shows that the individual is incapacitated. And so the best way to do that is to get a medical certificate or a clinical team report. I will say there are some times where you can't get a medical certificate. The court does have the option for you to be able to file everything, and you can request waiver of that requirement. It's very difficult, and it can be best to have other sort of supporting documentation if possible, affidavits, things like that, to show that there is information, there is evidence that they're incapacitated, even if you're unable to get the official medical certificate. But it can be an uphill battle, so it can be best to have a medical certificate or clinical team report. Also with those, the medical certificate, the court wants it to be dated within 30 days of everything being filed. And then whenever a hearing gets scheduled, they'll also want an updated medical certificate that's dated within 30 days of the hearing. So one thing to consider with the medical certificate. With the clinical team report, those are good for 6 months. The court will consider the examination date of the clinical team report, and from then within 6 months it can be filed, and if a hearing is held, it can be fine. Some judges view clinical team reports as being valid for even longer than that, recognizing that if a clinical team report exists, it's because there's a intellectual disability, so things are unlikely to change. But that's just another thing to consider with the timing of it all. So again, so you'll collect those documents, you'll fill out the petition and all those other pleadings that I had mentioned before, and you'll file all that with the court. And then in return, the court will issue a citation and notice. This has to be provided to all the interested parties, the family members, caretaker, and it also needs to be provided to the respondent or protected person and it has to be served in hand to them by a disinterested party. So notice is an important part of this process. Everyone needs that. And as part of the notice, it also includes what they call a return date that might be, 30 days later, something like that. And it gives all the interested parties and the individuals until that return date the ability to object if there are any objections to the proceedings. Someone might object because maybe they say, I'm not actually incapacitated, and so that the protected person might be the one objecting. Could also be another family member might object, saying, I don't want my sister to serve as the guardian, I should be the guardian. So those are examples of different objections that you might see. And so if there are objections filed, then the court will schedule a hearing to address that. If there's no objections filed, then the return date will pass. It's on the uncontested track. And then the next step will be a hearing. And before the hearing, the courts do a carry check. So they do a background check on the guardian and conservator. And then there will be a hearing. And so at the hearing, you'll appear before the judge and just kind of outline why you're there. And with an uncontested matter, it's generally very likely that the court will grant the request to appoint a guardian or conservator. And then after that, they'll issue the decree and you'll have letters of authority, which again give you that ability to act as the guardian or conservator. And so I just went through that whole process. And as you might think, it can take a little bit of time. By the time you file, you get the site, and then you have the hearing. It can take a couple of months, maybe 2 to 4 months. But there are instances where you might want to get in sooner. So the courts do have the ability for the request of a temporary guardian or conservator, temporary or kind of an emergency. With those requests, there are specific motions on the court website. These are the motions for temporary guardianship and conservatorship. And to accompany those, we often file an emergency affidavit as well as to why there is this need to have a temporary appointment or an emergency appointment. And a lot of courts also request or require a motion for a speedy hearing, again, just to get in even sooner. Examples of when temporary appointment might be requested. Perhaps someone was okay and then they got into a terrible accident. They didn't have a healthcare proxy, they didn't have anything in place, but they're in the hospital and not doing well, but someone needs to be appointed to make medical decisions, or someone needs to be appointed to be able to access their accounts to pay their rent while they're in the hospital. In those instances, it could be appropriate to seek temporary guardianship or conservatorship. Could also be the case where someone might be unfortunately a victim of financial exploitation and continues to spend their money or try to do whatever they can to give money to a scam or something like that. Then seeking temporary or emergency conservatorship might be needed in order to stop them from having access to their funds. So there's some examples that could come up, or some reasons why temporary or emergency appointment might be needed. So that pretty much sums up the kind of brief overview of guardianship and conservatorship. I know that I have covered quite a bit regarding the differences and the process, and I'm happy to do my best to answer any questions.
Thank you so much, Ilana. Did you see I sent over one? Can you read it over there?
Yes, let me take a look.
Okay, so I'm gonna keep sending them to you.
Okay. All right, so one of the questions is that if someone's incapacitated and does not have a healthcare proxy or power of attorney, someone else would have to someone else have to file the petition on their behalf? And that's correct. And so, sorry, I'm just trying to figure out how to scroll on this. No, that's okay. So, right, so someone else would have to petition, and the petitioner might not necessarily be the one seeking to be the guardian or conservator, but it would be someone other than the incapacitated person that would have to go into court and file something. I don't know why I can't see the full question.
All right, well, how about I ask? I'll ask, and then you can.
I think I got. Hold on.
Do you want me to ask them?
I think I understand. I don't know why. I can't read the whole question.
Okay, so I'll read and you answer. Okay. Okay, solar agers may have the need to find a trusted person for their estate plan. What professionals can step up and serve as a power of attorney or healthcare proxy? Example, daily money managers for a POA or professional fiduciaries.
So I think, and just in terms of having a professional appointment, I think that it depends on the situation. I think that some attorneys feel more comfortable serving possibly as a power of attorney or as a conservator than a guardian. A guardian, you know, they make really sensitive medical decisions. And so sometimes it can be best to have a family member involved with that. But of course, if there isn't anyone, then there are professionals involved, or professionals that are out there that might be an attorney or might be someone else that could serve as a guardian or conservator.
Okay. What happens if there's an elder who's married? Does the spouse have the right to be guardian or conservator? What if the elder daughters want to challenge the spouse? Are those claims ever successful? Do you have any experience with that?
It's a good question. There is, have to look back at the exact statute, but I do believe there is sort of a priority of appointment or consideration for family members when it comes to being named as guardian or conservator. I think that the spouse and the children would all be given notice of these proceedings. And so if a spouse is seeking the guardianship or conservatorship, but the children have concerns, then they could certainly file an objection and voice those concerns. And I think it would be up to the judge and the court to determine whether there's any validity to those concerns or what might be appropriate or things like that. But the children can certainly object.
Okay. Any thoughts on emergency temporary guardianship?
I mean, I think as I mentioned, it's definitely an option, and it could be appropriate depending on the circumstances. I think that I think it depends on whether what's going on. You know, I think as I said, if there's an accident or something like that where they're in the hospital without any advance notice, then having an emergency or temporary guardian might be needed. Often we do the temporary and permanent pleadings together. So we file everything and try to get in quickly to be able to have someone appointed as a temporary guardian. Those appointments are generally good for 90 days, and then the court would schedule another hearing to address permanent appointment at that point, or maybe it needs to be further extended if there are any issues, if there's any contested issues or things like that. The temporary appointment could be further extended.
Okay. Can expanded powers be included from the outset of conservatorship? For example, an estate plan modification?
It can be. You can request it as part of that. We've done that. We've even filed a petition that doesn't include it, and then as the process goes, recognizing that this might be something we want, and so filing a motion to amend the petition, requesting that additional authority. So we've done that kind of thing. Again, oftentimes with that, the court might appoint a guardian ad litem or counsel for the protected person. So it could take a little bit more time, but it is definitely something that you can request at the outset.
Okay, and then when filing for conservatorship, does the proposed conservator need to attend the court session, or do only the lawyers attend?
Good question. I think it depends. I think that if they're, depending on why they can't be there, then the attorney might be able to file a motion to waive their appearance. I think that'd be something to discuss with the specific attorney in the matter.
Okay, let's see. This one's a little longer. If a client is incapacitated and doesn't have a named healthcare proxy or power of attorney, it sounds like someone else on the client's behalf needs to petition for both guardianship and conservatorship separately. Is that correct?
Yes.
Okay. Let's go. If we have a disabled child, adult child, will a healthcare proxy allow us to access to talk with her doctors?
I think it depends on what the healthcare proxy says. If the child did execute the healthcare proxy, then it might be able to give the named healthcare agents access to the information. Sometimes the doctor or facility might require a separate HIPAA release form. It's something that as part of the estate plan might be drafted. So you might need a separate HIPAA release in addition to the healthcare proxy in order to have access to that, to the medical information. I think at that point it might be up to the specific doctor or facility as to whether they need another document, or if they won't recognize the healthcare proxy, they might say that, and they might say that guardianship is needed. That I've seen that before, not necessarily in this specific kind of situation, but where a parent or an individual or child, someone is trying to have do something on behalf of their other family member, and then they're told that the healthcare proxy, power of attorney, or guardian or conservatorship isn't sufficient, and they have to go to court in order to get that specific authority.
Okay, and then I think that is all that we probably have time for, but just I did see one that said, are we providing the slides? We are not going to provide the slides, but you will have a copy of the video, so you can take a look through there. But we can't send out the slides for this. So with that, Ilana, thank you so much. If we didn't answer your question, I will send these over to Ilana and see what we can do. And hopefully this was informative and helpful. And thank you so much. And take a look in the next week for the recording of this. Hope everyone has a great day.
Thank you.